to our Lunch and Learn workshop, the next in our series for 2023. If you're not sure of me, my name is Paul Jantz. We're here thanks to Professional Partners Education and our wonderful supporters at Hall Chadwick, Profit Master Global Outsourcing, iKeep, and Lloyd's Auctions. Now, a massive shout out to Danielle Morrison. I'm pretty sure Danny's online, but Danny usually shoots out the invitations to all of you guys, which then enables you guys to register and jump on as friends of Hall Chadwick and PPE, or Professional Partners Education. I know a number of you, these sort of lunch and learn workshops have worked out to be quite good as well, because I know a number of firms get their teams in their boardrooms, they get some lunch in there, and they allow obviously team members to sit there and learn just as much. So if you're sitting in your boardroom, welcome. If you're joining us for the first time, welcome. If you've missed anything, probably, because these are run on the the second Tuesday of every month. It's hard to believe it's the 8th of August. Second Tuesday of every month. So if you've missed anything in the past as well, you are more than welcome to go to our YouTube page. It's PPE TV Plus on our YouTube channel. This content, whether it be our lunch and learn content, whether it be my masterclass content, it's all free for our community, our accountants. So please feel free to jump on there, subscribe, and then as soon as new content is put up there, you'll get a notification. Now, today's topic, we're talking about voidable transactions, and we're going to be looking at the current as well as the likely future changes. And we've got a special guest joining us probably for the next 35, 40 minutes. We've allocated 45, and there'll be questions. You've got the chat bar as well as the Q&A there to use as much as you like. If you like something or you're not sure about something and you want to ask the question, I'll definitely come back to that. So we'll allow probably 5-7 minutes at the end of this for any questions. Let me introduce you to our guest, Amy Weiner from SLF Lawyers. How are you, Amy? Welcome.
I'm good. Thanks, everyone, for having me.
It's wonderful to have you here. I know we've done a few things with SLF, so I'll give you the opportunity, first of all, straight off the bat, to tell us a little bit about you. We'll go through our topic again, avoidable transactions or unfair preference payments, but tell us a little bit about you and SLF.
Awesome. So thanks, everyone, and thanks for taking your lunchtime today to attend the seminar. As I said to Paul this morning, I'm going to keep it as light as possible to ensure you're all not asleep by the end. So a bit about me. I'm Amy Weiner. I'm one of the senior associates in the Melbourne office. I deal mainly in commercial litigation and insolvency. I've been at the firm for nearly 2 years, actually, and I've been a practicing solicitor for 10 years. So a bit about SLF, we're a full service firm, commercial firm. We have areas of property, commercial, family, any department we can do. And we are all up the east coast of Australia. So in offices in Melbourne, Sydney, Gold Coast, Brisbane, and satellite offices throughout Australia. So whatever jurisdiction, whatever area you've got, we can handle it for you.
Magnificent, well said. And I suppose these lunch and learns take a bit of a, call it a insolvency liquidation twist, and I suppose that's where the voidable transactions or an unfair preference payment comes into it. So let's kick off. What are we sitting at? 12:04. Brilliant. So let's talk about that. So what is an unfair preference payment, and what can a liquidator pursue?
Excellent. So as I said before, I'm going to keep this as broad as possible. What my aim today is to teach you very much an overview of what can happen, what a liquidator can pursue, what things to look out for, and what trends. So please, during this chat bar or any time during this presentation or after, if you've got queries, please let me know. If I'm going over old ground, I apologize, but I want to use this as a background, but also a refresher. So a lot of you might know that when a company's wound up in insolvency, the role of a liquidator is to manage that winding up process, but it's also to investigate those affairs of a company and to realize any assets for the benefit of those creditors. Now, what the liquidator can do, which is a very important role, is they can investigate what's known as voidable transactions. Now, they cover a whole raft of transactions. They might be, for example, director-related loans, uncommercial transactions. But one thing they can look at is what's known as unfair preference transactions. So really, in short, an unfair preference transaction is a payment of funds or a transfer of assets entered into by that insolvent company, which really briefly provides unsecured creditors the benefit of that transaction over those other creditors. So the whole point is that creditors must be treated equally. So the liquidator can have a look at those transactions, have a look to see if one creditor, for instance, is preferred over the other creditor, and then they have their powers within the Corporations Act to what we say is claw back that transaction. So it's a really important tool, not only for a liquidator, but as accountants, you need to be aware that your clients potentially may be the subject of these transactions and that they may get these letters from liquidators or from law firms banging down the door saying, pay us back that money.
Interesting. I was about to say, before you said the word clawback, I was thinking, so these are payments that are made, and then if you find in your investigation, you can actually go and knock on someone's door and say, hey, Paul, that payment for $10,000 that you received is no longer valid. You now need to pay that back.
Yes. And it's funny, I say that they're unfair, and it's meant to be unfair to the body of creditors, but sometimes it's really unfair to the person that's received that payment, because they turn around and say, well, hang on, I provided goods, I provided services. I had no idea what's going on. I'm not paying that back. That money's rightfully mine.
Well, I don't know if we've got time to go into that. That's exactly right. That's what I'd be saying. You know, if you've already provided a service or a good, and then you're entitled to that payment, and then someone knocks you, it's like, well, hang on a minute. I've done the work over the last 30 days. I've been paid, and now you're telling me, and I've got to pay that back. No, I need that.
Exactly right. Well, there are defenses to it, which I promise I'll go into later. But yeah, it's an interesting body of law that, as I said, we could sit here and delve deeper into it than the 45 minutes, but that's sort of the overview of what we say.
So let's delve into that a little bit. Let's delve into the history, I suppose.
Sure.
How did this all come about? Sort of how did the reason come about?
Yeah, so I'd said, when I like to look at things, probably this is just my personal learning, I like to know why these came about, what happened, so then you know that framework of what you're looking at. So it actually came around in around the 18th century. This is not a new concept that's come around. But the concept, like I said before, is that the general body of unsecured creditors should be treated equally, and they shouldn't be treated that one is preferred as opposed to the other. It actually came around in bankruptcy. That's where it started off. And it was based on provisions in the Bankruptcy Act. For example, in Australia, it was based on the provisions of the 1996 Act, which was in the bankruptcy legislation, which then came effect in the Corporations Act in around the 1990s. And that was as a result of various amendments. It's going to bore you all, so I'm not going to go into that. But the main reason is that it allowed that power of that liquidator to come and collect those monies and come have a look at those transactions. Now, this isn't something that's to Australia only. Obviously, in Commonwealth countries, there is this concept. They also have similar concepts in America and the US bankruptcy code as well. So this is a concept that's known not only in Australia and those Commonwealth countries, but also worldwide.
Okay, so who actually governs this regime?
Yeah, so it's governed by the Corporations Act. For those nerds out there, it's 588 FA of the Corporations Act.
That's what we love to hear, isn't it?
100%, because I know that afterwards you're all sitting there looking at the Corps Act going, I want to know what she was talking about.
Hang on. Now repeat that again. What was it? 588?
FA.
FA.
Capital FA. And there's various components of that, but trust me, if you want to look in there, it's very easy to find. And as I said, how I like to look at it very simply is that there's certain elements that a liquidator has to establish in order to go after those preferences. So Paul, as we were saying before, it's not just, hey, I received the money, you need to pay it back. So there's 4 main elements in an unfair preference transaction. Now, there must be a transaction, so that must be a transfer of money, a transfer of assets, something along those lines. The company must have been insolvent at the time the transaction occurred. That creditor must have received a benefit over other creditors. So what that involves from the liquidator is to do an analysis of working through, well, hang on, creditors at that stage would have received X amount in the dollar, but you received Y amount in that dollar, and therefore there was a preference. And that transaction needs to occur within 6 months of the relation back date. Again, we can go into what the relation back date, how it is, and the Insolvency Law Reform Act actually gave some clarification as to that date, because there has been a little bit of toing and froing as to how to determine what that date is.
Yep.
The purposes of this chat, and as a very broad overview, it's usually the date the application to wind the company up was filed. It could be then manipulated if there was an administration an administrator appointed on there, or if there was an administration and then there was a liquidation. It is varied, and it is within the Insolvency Law Reform Act that does say which date you look at. And as I said, there is jurisdiction and there is commentary all around which date it is. But if you broadly think it's around 6 months from the date the application to file the company came out. Now, as I said before, they're the 4 elements that the liquidator has to meet. It's very clear. There's no wiggle room. There are various defenses. As I said before, I got the money. Why do I have to pay it back? I had no idea the company was insolvent. That's not fair. Now, there are various defenses, and I'll discuss later on that these defenses have actually changed in the last 12 months, which is probably the largest change we've seen in this body of law for some years. And it's really caused a bit of an uproar. But in short, there's defenses of the fact that there was a running account between the company. There was the relationship of multiple transactions. People were dealing with the company and they kept having a credit relationship as how did we meant to know this was going to occur? There can be things called the ultimate effect. In the end, you kept supplying goods and services so I could continue to do the work, and therefore you were inducing me to provide those goods. And of course, one of the most probably used defense that everybody uses is that good faith defense. And that's what we spoke about, as in, I had no idea that company was insolvent. They were paying their invoices. We use them all the time. Nothing was late. I didn't chase up money. So there's a body of law that talks about that suspicion of solvency. And there's various factors that people look at, for example. So in my head, I always look at the main ones, which I said, history of late, unpaid sales deliveries, dishonored payments, were checks bouncing, were payments promised that never came in. Was there an absence of transactions over a period of time? Did that company, for instance, stop using your client? And then we're like, hang on, we now owe that money. Was there an extension for credit terms? And was there, for instance, other enforcement actions that you knew? So were you aware that somebody in the industry also put a statutory demand out for them? These are elements which clients need to become aware of that may raise that suspicion of solvency. And to be clear, it's an actual and existing suspicion of insolvency rather than simply a feeling that that may occur. So I'll go into a little bit later, but the other defenses that have occurred, for instance, in relation to set-off, have been abolished in the last 12 months. I'll go into it a little bit later. So they're the real main defenses that people can look at. But as I said, the suspicion of solvency and the good faith is really the defense that a lot of defendants rely upon. And that brings...
Well, have I lost you there? I think I've lost you.
Fairness back into that.
You there, Amy?
Yeah, sorry, that just froze. I'm here now.
There you go. The beauty of live, isn't it? Because it definitely froze there. And I thought, oh, have I lost you?
I was the same. That's all right. And I'm not good with technology. So if it did freeze, we would have had a problem. So sorry, guys.
That's what everyone online loves nowadays, isn't it? So going back to that, it's an interesting one because you raised a few things that probably call it red flags, and for all the accounting firms online and their clients, sort of looking at some of we've looked at the practical side and what that means in reality. Is it just those signs to look for that we should be raising a flag and being aware of, or is there more there?
There's a lot of signs that you should be aware of. Those were sort of the main signs. There's a case, again, called ASIC versus Plinum that really talk about those main signs that people need to look at. But I think what I would say in a practical point of view is that you have to have a look at the relationship as a whole between the parties. Have a look at what has occurred. Have a look at the payment history, the process between the companies. Have a look at what's going on, because at the end of the day, what it means is that if those elements are met from the liquidator and you can't raise those defenses, the problem is they're going to be, as we said, clawed back, and you're going to have to repay that money. Now, whether that company can repay it or not, $10,000 might be significant to some company, and that might be the preference, but you could have $1 million, and that's a problem. And what actually occurs even worse is that we have to know that the ATO has very special powers, and the ATO under these powers might even look to those directors of that company and say, well, hang on, there was a preference payment. We didn't realize this occurred. the ATO turns around and said, okay, well, I'm now going to go after the director, and they can provide an indemnity in relation to that. So it's a really important concept that a liquidator has up their sleeve to chase these payments, but also you've got to be careful that you're not paying back these monies for goods and services that were rightly given. And at times you might be owed money as well from that company. So everyone needs to be really cognizant of what has occurred and look at that relationship between the parties.
Okay. So let's look at how we manage exposure then, because this is probably what it comes back down to, isn't it? So
absolutely.
How do we actually manage that moving forward? What's the advice you can provide to everyone online?
And I was thinking, when I was thinking about this, and something that I really wanted to make clear to everyone in the room, and I thought about my years of experience and how I see clients and how I see that people have raised certain defenses. And I sort of did a checklist of what, in my view, I see come up as most important, and how I think people, stepping from the other side, because I don't act for those clients. I don't sit there and give them that advice. I'm on the other side. So as I said, this checklist is my checklist. This is what's come from my experience. But I think the most obvious and most important way is ensure that your client's not a creditor. That's the very first element you have to look at, is that it can only be an unfair preference if they're a creditor. So if they're never a creditor, tick, hurdle number one is gone. The liquidator's not going to sit there. So for example, if you're not a creditor, ensure cash on delivery, ensure that there's prepayment of goods. Okay. Take that from the very start, that if you think that your client is dealing with a company that might be insolvent, put them on the start to say, hey, there's a little bit of a red flag here. Let's get on this on the front foot, because trust me, it's going to be easier on the front foot than it is on the back, because it's not fun chasing after a liquidator that's wanting their money back, because they will chase.
Yes.
Sorry.
No, that's all right. My brain's working at the moment, so it's good.
No. So the other one as well is obtain security. So ensure, for instance, do you have caveats over the property that the company might have? Do you have a PPSR registration? Ensure that you have some form of security to help ensure that that payment is going to be made. Because again, an unfair preference can only be in relation to an unsecured debt. When it's a secured debt, again, we're out, finished. Liquidator's got to look at this and they're not going to pursue you. Another one is to help ensure getting personal guarantees. If the company goes under and there's a liquidation and they chase you for an unfair preference, or for example, your client's owed money. So let's say, and again, I'm not an accountant, so excuse my easy numbers because it's not my thing. But for instance, if you're getting chased for an unfair preference of $10,000, but you're owed $100,000, well, then you've got that money to recoup. You go after the director, you sign a guarantee. That's gone. The company's finished. We can't go after them anymore, because you can't pursue a company in liquidation without leave of the court. And why would you? Usually the company doesn't have money. So go after the director. They usually have something to hold on to that they want to try and settle this money. And then use that as your fighting funds. If the liquidator is then coming after you, you could say, well, hang on, I've tried to recoup most of my losses here. Again, I think this is really good from the front foot, and to ensure that I have no doubt terms and conditions of your clients will try and have these clauses in there. Another one is stay on top of your debtor ledger. Have a look at the running account. Are there payments that are continuously coming late? All of a sudden, they were great payers. They've had the relationship for years. What happens if there is all of a sudden payments are 5 days late, 10 days late, and then it continues to escalate? So stay on top of that. Ensure the credit department is always looking at things. Ensure you continually look at that relationship and monitor. I mean, it's good for cash flow in any event, but it's a really good tool. And then my last tip is, as soon as you receive a demand from, whether it's a liquidator, a lawyer for an unfair preference, get all your ducks in a row. Get as much information as you can. Have a look at what is being asked of you. Ensure you engage a legal representative at this stage and have all that information to say, hang on, this is what's happened. We had no idea. Here's the payment history. Keep your records and be proactive. Liquidators are like any other industry. If you continually engage with people and continually ensure that you're on top of things, it actually makes everybody's life easier and people want to deal with you. This is no different to any other industry. Putting your head in the sand, does not change anything. And especially something like this, because I mean, my view is that if I'm going after clients that I think have an unfair preference that I've been spoke to, if they're proactive, they're wanting to engage, and they're probably wanting to engage in settlement discussions, you're more inclined to do that, as opposed to somebody that's honestly sticking their head in the sand, ignoring emails, ignoring everything. Because my advice at the end of the day is then pursue that further. Go after formal legal action, because we're not getting anything from them.
Correct. Correct. And I think that's and we've done a bit of this where to the accounting firms that are online, where they can start, and I know compliance is tough, and I know finding team members to do compliance is tough, but this is where the next stage of working with their clients is just so important. And you spoke about the debtors ledger or those flags, whatever it may be.
Yeah.
And I think certain industries, let's talk industries for a second, because let's say the building industry has been smashed again by the amount of companies, the large companies that have gone under. I know there was talk again of another one only 2 weeks ago, wasn't there? Or
Yes.
last.
Continual.
Well, that's right. And that was a big name. You know, when you're having those big names in financial trouble, the knock-on effect to the smaller guys, which is probably some of the clients of the firms online, could be quite huge.
Absolutely. And it affects everybody at the end of the day. So, you know, if you've got a lawyer on hand, or you've got someone that you can speak to, pick up the phone. People are willing to help. For example, we have clients call our office all the time. I received this, don't know what to do. I can't do this at the moment. Can we get this to you? But we need another 2 weeks. You know, write back, hey, got your letter. Not quite sure what this means. I will respond in 3 weeks. Just continually be on touch. You know, people appreciate that update.
Yeah, I think it's whether it's lawyers, and I think lawyers, we tend to, as everyday people, not you, because you're one of them, that if you get a legal letter, it tends to scare the pants off you a little bit. But you're right. You can either put it in the drawer and ignore it, or you can actually be proactive, a bit like the ATO. The ATO always talk about just communicate with us, talk to us, tell us where you are, tell us what you can afford, tell us what you can't afford if you're on payment plans. These are all the things that, again, directors of companies can start doing.
Absolutely. And, you know, ensure your records are up to date, ensure everything is kept, ensure that you have updates as to history with the company. But again, as I said before, have a look at it from the very start. Do you have red flags about this client? Are you unsure? It may be that that's going to bite you in the butt later on if you don't take those measures from the very start to protect yourself, to ensure that you are not going to be subject to these payments. Yep.
And I think that's always the fear as well to a lot of clients is, well, we want the work now. We've got the work, we've got people, we've got capacity. We'll take on the work, but then, they're not paying us for, hang on, our terms were 15 days. Suddenly it's gone out to 45 days. Suddenly it's 60 days, but we're still doing the work. So you've got greater exposure, haven't you, really?
Absolutely. And as I always say, it's not work until you've got the money in. So what's the point of doing this work and continually to do it when potentially that money can go? You're better to focus on something else.
Yep. So true. And then again, that's probably for the accountant there, the opportunity to almost that consulting type of role to start talking to your clients about those types of, it's managing exposure and managing risk at the end of the day, isn't it?
Yeah, and it's in an environment, we're in a really risky environment. As you said, these large building companies or these large construction companies that back in the day you never thought would ever have insolvency issues, or clients that you may have never thought would ever experience these issues, are actually now being exposed to that. The Australian Taxation Office are going so heavy on director penalty notices, which relate to bankruptcy of individuals. They're going so hard on statutory demands at the moment. So the people that you think are safe, or that you always thought would, you know, they'll pay me, it's okay, we've had this relationship. You've really got to have your ears pricked up at the moment to realize that, in my view, no one is safe in this environment, which is unfortunate, but at least all we can do is manage those risks now, rather than simply understand that they exist and continue to move forward.
That's right. And whether it's to the firms online, whether it's contacting Hall Chadwick as an example and talking to the guys that are in the insolvency teams, or talking to you guys, and
absolutely
having that extra layer of information armory at your disposal to go and talk to your clients. Say, hey, I've had a word to these guys. Here's some options you need to consider. How about I bring them in and let's chat? Again,
absolutely.
the role of the accountant consultant. We all know you want to do the right thing by your clients, and you care very much about your clients. And this is what these are about. It's about empowering you guys with information that you can actually take some really proactive steps.
And understand people are happy to help. I mean, I can only speak for myself, to be honest. I'm happy to have a 10-minute conversation with someone that says, hey, I saw you online on this Tuesday. You spoke about this. I think our client's in a bit of issue. What can we do? What to look out for? People are happy to help at the end of the day. So again, be proactive. Tell everyone to get on the front foot and really help out those clients to ensure that there's not issues.
Yeah, well said. Well said. Now, let's talk about some future changes. So is there anything there that you can share on what we can expect to see in the future?
Absolutely. So look, there's been reforms that have been discussed in the last year or so in relation to potentially the quantum that people can chase in relation to avoidable transaction and in relation to the time frame, whether it's 6 or 3 months. Now, those changes are still up in the works. But what I mentioned before and I alluded to is one of the biggest changes happened earlier this year. And what that was is that the High Court handed down 2 very important decisions. And it was in relation to not just voidable transactions, but unfair preferences in general. Now, it didn't change the transaction itself as to what the liquidator must satisfy, but it changed the defenses that were available in order to defeat these transactions. So very, very briefly, they spoke about a set-off, and a set-off is no longer allowed as a defense. There are exceptions. So again, please excuse it. This is a very broad general topic here, but that a set-off cannot be used as a defense to an unfair preference. So what that would mean is, for example, liquidator goes after company, says, hey, again, I'll use the $10,000 example. You owe $10,000. That's a preference. Pay me back. Company says, well, actually, no, you owe me $100,000. So therefore, it's only 90. That's out. Doesn't work anymore. So that was always a really important tool that clients could use to defend those transactions. Again, I've taken a very broad brush approach, but at the end of the day, that set-off is not available. The second change that occurred this year is what's known as the peak indebtedness rule, and that's been abolished in its entirety. So what that meant is that, and it's a difficult concept to grasp, so I'll make it as simple as I possibly can to ensure I've still got everyone's attention. But basically, liquidators could look at the highest point that funds were owed and then have a look at that indebtedness of the company, and then have a look during the period as to what occurred. Usually these fluctuate. And what they could do is they could choose the point, what's known as the peak indebtedness. So again, you were owed $100,000 at a peak, and therefore we're going to claim that. That's been abolished. So that had a very difficult accounting exercise to do. I remember sitting there late in the office at night trying to do graphs as to which indebtedness, where it goes. That's been abolished in its entirety. And that peak indebtedness is no longer allowed to be applied by liquidators to say this is the point in time we're seeking that. So look, as I see this area becoming of greater importance to both liquidators and obviously creditors, I think that there are going to be some future changes. I think there are going to be some trends, especially in this ever-changing market and this ever-changing backdrop that we're seeing with these companies going under. So these were 2 massive changes that occurred in February with these High Court judgments. I think that there will be reforms. I think that people are going to be looking further at those changes and to try protect those creditors, but also to empower those liquidators to look after that money and chase that money for the body of creditors. So my final thing is watch this space. I think there will be changes, and I think it's only starting now. I think the raft of litigation is going to continue. People are owed money. People are desperate at the moment. People are going after those funds to try recoup those funds. And I think that the litigation aspect is going to increase, and therefore the body of case law will change, and we'll see various changes happen. COVID obviously changed things. People are a little bit quiet, but my thing is have a look to the next 2 to 3 years. And I think if I was presenting this presentation, my changes would be very different.
Interesting. And so those 2 changes that came in, you say February, they came in February this year?
Yes, 8th of February this year in the High Court judgment. So again, happy to explain to anyone offline what they were, what occurred. But any Google review would be unfair preference changes February 2023. I promise you'll get a whole heap of things about Badenoch and all these cases that came through. Every law firm decided to write about them. So you'll be able to have a look and see what those changes are and the impact that they will have. But that was the broad overview of them.
Brilliant, brilliant. Well done. Now, to all you guys online, if you've got questions to Amy, throw them into the Q&A or the chat bar. We'll keep an eye on that because we'll be looking to wrap up in probably about 5 or 7 minutes time.
And the other thing I wanted to say as well is that if anyone in the chat or Q&A, which I always like this when I do presentations, is if anyone wants to share any stories that have occurred that they have seen with clients, you know, share it to the group. We can all learn from each other. We can understand what has occurred. Feel free to say, you know, I had this client and this is what occurred and this is what we did about it, or this was the flag. So I encourage everyone, I know it's a bit daunting, to share any experiences they might have in this Q&A. I spoke for half an hour. You can't get more daunting than that.
No, look, but to be fair though, you're right. And anyone, that's a great little suggestion. So anyone that does have any of that, I know it might take a while to type all that out. A little texting, it depends what you're using. But yeah, great little, if you got little war stories, let's call it, to share that others can benefit from, I think it's fantastic.
Absolutely.
Amy, while we're waiting for any questions to come through, thank you. Brilliant little session. Is there anything that, again, that we've maybe missed out on that you wanted to just end with?
No, nothing at all. As I said, I think it's just a matter of being aware and being proactive. This is my biggest tip for you. As probably said it about 40 times during this presentation, is don't put your head in the sand. Make sure you get on things on the front foot. Don't allow that to continue to fester and then go through that. And again, if you've got questions, speak to the insolvency practitioner, speak to the lawyers, have a group of people around you, or have a group of people that you can arm your clients with, that they can chat to and they can have a look at these issues. Because I guarantee half these issues are not the first, second, or fifth time that we're going to see that, and we will have the advice to assist you.
100%. And that's what we say to a lot of the firms in our community as well. And that's what's great to all of our firms out there. We've got a great fella by, if you came onto our last lunch and learn, Andrew Crawley. Andrew Crawley is not a liquidator, but he comes from the client's perspective and provides proactive options, solutions that, yeah, you can consider. You can bring your clients in. And you know what? To have those sort of chats, they cost you nothing. But what it can have as an impact to your clients, the directors, is massive, especially if you've got husbands and wives sitting there and the wife's another director and she probably doesn't know what's going on within the business and she's probably about to lose her home. I'll guarantee you there's solutions there that you want to work with. So, absolutely. And that's what we do at Hall Chadwick here as well. And Andrew Crawley, reach out to him if you know there's anything you can do. And I know Danny will as well. Amy, before we wrap up, where can people find you?
Awesome. So you can probably have a look at the SLF Lawyers website. So slflawyers.com.au. My email for anyone that has a pen is aweiner@slflawyers.com.au. All our contact details are on our website. If you want to have a look at the areas that we have, what we practice in, or again, contact Paul, contact Danielle if you want to reach out, always available.
Yep, exactly. I know Danielle works very closely with you guys, so we absolutely. So yeah, we've always got options available. So and I think that's the key thing, that you know these are about, we have options available to help you, to help your clients. So reach out and have a chat.
Absolutely, and happy to have that chat.
No questions. See, I said this at the start. I said, the great part is if there's no questions, you've covered all the topics, which is great.
Well, hopefully you're all awake by the end of this and I haven't bored you to tears.
True. We haven't lost anyone. That's the main thing. So that's good. It's good.
Well, awesome. Well, thanks for the opportunity.
No, look, it's our pleasure. Look, it's great to, again, extend another layer of what we can do to having experts like you guys online and sharing, again, your experience with all this without going into the technical detail of it. Then, to be honest, when I heard the voidable transactions, I didn't even know what it was myself. But when you break it down, I actually totally understand from a company's point of view how that works. So thank you. It's been fantastic.
My pleasure.
So, to all of you guys online, thanks for joining us. Again, this is our August Lunch and Learn. Hard to believe we're in August already. My next masterclass show So it's not going to be till later this month. So we're talking about mastering business processing automation. So again, I know being in the accounting industry for a very long time and working on processing efficiencies, performance, I know I've helped a lot of firms through that. And I've got a very special guest joining me for my masterclass show on the 29th of August. And that's Stan Corner, very well known within the accounting industry as well. So look out for that invitation. Amy, any parting comments?
Absolutely not.
There's no questions.
Enjoy.
Exactly. If you're in Melbourne, the sun's out. Enjoy it. It's been very cold this morning. So till I see you next time, thanks to everyone for joining us. Amy, thank you again.
My pleasure.
Have a great day.
See you, everyone.